Oh snap. Welcome back to the channel, y'all. The Mystery Project. My name's Patrick. If you like true crime, breaking news, all kinds of stuff, we talk about all of it here, y'all. Hit that subscribe button, would ya? Hit the subscribe button. Hit the little bell icon. What do you do on YouTube? I don't even know anymore. Do all the things. Oh shit, and of course I'm gonna screw it up by forgetting to mute the damn other stream. Imagine that. I hate when I do that. Alright, y'all. New format on YouTube. What do y'all think about this? You know, I'm constantly trying to upgrade, upscale, make it cooler for you guys. Thanks for all the stuff over on TikTok too. I see y'all coming in with puppy dogs and all kinds of stuff. We need 100 of those things. But y'all, check it out. Give me a thumbs up in the chat if you're digging this little layout a little bit better. I think it looks pretty dang cool. All right, let's jump in, y'all. Lori Vallow, she was in court. Lori Vallow in court. What? I know. So apparently they're trying to she was trying to get her mental health evaluation canceled. Let's find out what happened, shall we? Let's do this.
All right, I set the status conference pending a hearing at the Rule 11 court last week. So what's the status, counsel?
Oh, hell. By the way, TikTok, thumbs up. Can you guys hear that all right?
Yes, Your Honor. And just to briefly put on the record, what we didn't put on the record was we had requested to seal this hearing because it does discuss sensitive information. I understand the prior court's ruling, but just to have on the record that we did request that it be sealed. So where we're at with, we had a hearing, an initial Rule 11 hearing with Commissioner Mortarosian. He had received the reports. One of those reports is competent. The other doctor indicated she wasn't able to make a report, even though she had done a records review. Commissioner Mortarosian, from my understanding, was willing to stipulate to competency based on the one report. Even though Ms. Vallow wasn't present, it's outside their normal process to stipulate to competency if a defendant's not there. But given the unique circumstances, he was, at least it was my understanding, he was willing to do that. However, the state objected, wanting Dr. Hernandez's report. So what I would like to do is go back over the LeCount case because I think it's completely on point with case law and where we're at with this case.
Oh, hell.
So when we started with you, I believe it was on November 6th.
Is it just me or does she sound like nervous as hell?
You had indicated that you were willing, at least inclined, to withdraw prior counsel's Rule 11 motion until Ms. Vallow indicated that she wanted to represent herself. We brought up the LeCount case. I went back through that case pretty thoroughly, and I'm just going to kind of walk through it. That case starts off with that Ms. Vallow has an absolute right to represent herself, and then it goes into what has to be established before she can represent herself. She has to show a sufficient mental capacity to understand the nature of the dispute, formulate a defense, and engage with court, counsel, all of the people in the cases.
Y'all, and if you're just tuning in, you're like, who the heck is this lady? Lori Vallow. Remember, she was the one in Utah with Chad Daybell, and they found the kids buried in Chad's yard and everything like that, JJ and Tylee. Remember that? And then like her brother passed away of like mysterious mysterious circumstances. Mysterious circumstances. And like her fourth husband did too. Third husband, I think as well. You remember? Yeah. Ooh, Lindsay! Thanks for the goose. Y'all appreciate it. Y'all hit me with a little goose action. Duck, duck, goose. Hit me with these things. What is this that we're trying to get? That's my life thing. But yeah, so she had a hearing today about, or it might have been yesterday actually, but it was about her mental health evaluation. So I guess she has to have a mental health evaluation. Because I think, aren't they trying to make it to where she doesn't go to prison, but she goes to like a hospital? I think I heard that. Let's keep going.
The court can look at, the court has to look at some evidence in order to make that finding of putting her in Rule 11 before allowing her to represent herself. But there has to be a history of irrational behavior, some medical opinion documenting incompetency.
I mean, there is a history of irrational behavior.
You what?
But, I mean, that's basically anybody that takes the life of somebody else. That's irrational behavior.
How dare you?
So, you know.
Or something else, and the defendant's demeanor. So the court has to find reasonable grounds. And that doesn't include an uncooperative attitude. You have to have a reasonable doubt as to her competency before we can place her in Rule 11. And the last part of LeCount talks about potentially just doing a preliminary evaluation and maybe getting one report before moving into a full Rule 11 evaluation. So I'm going to walk through what we have in this case. Again, she has an absolute right to represent herself.
Yeah, she's got like a you know what I mean?
She has the sufficient mental capacity to understand the nature of the dispute, formulate a defense. We've now had a couple of conversations. We believe that she's able to do that, so we are avowing to the court that.
Oh, Missy, thank you. Yeah, okay, so this isn't even in Idaho. Yeah, you're right. I forgot about that. This has got to be in Arizona where she's facing charges for what happened to Charles Vallow.
Bruh.
Sorry. I had a bit of a moment there, but I think we figured it out. Yeah, you guys are right. Yep. See? Can't get anything by me.
She's able to do that. So far, there's been no history. The state and your honors
I
had
don't
this
blame
case
them,
for
Create
almost a
Waves.
year. You've had chances to see Ms. Vallow in court. To my understanding, there's been no history of irrational behavior. We now have a medical opinion from Dr. McGady who says that she's competent. There's been nothing else in her
Did that
development.
doctor meet with her?
He spoke with her briefly. He didn't do a full evaluation, but he did speak with her. He did do a records review. I will point out his records review, his report, he kind of summarized what all of us have been saying was that maybe the Rule 11, and I don't want to get into previous counsel's thoughts, but Your Honor told us last court that you weren't really sure that you should have put her in Rule 11. We then showed up and said, we don't think this should be here. Dr. McGady's report, he did a review of CHS records and basically said maybe this stemmed from a disagreement. So again, uncooperative behavior doesn't equal incompetency. Again, she hasn't displayed any irrational behavior. You have Dr. McGady's report. As far
Oh my word.
waiting around for Dr. Hernandez to do a report, we have concerns about that. She's already wrote a letter to the court indicating she's watched movies about this prior to being appointed. She's gone outside of what my understanding of typical Rule 11. If you have a client in Rule 11, they refuse to talk to the doctor. The defense attorney shows up at that initial 11 hearing, says, I've now gone and spoke to my client. They didn't really fully understand. Now they're going to cooperate with the doctor. Then the doctor goes back out a second time. We've spoke to lots of attorneys in our office. We've spoke with our attorney who's in Rule 11 regularly. It's very rare that a doctor attempts to go back out to speak with a client a second time. Normally, I would never advise a client to not speak in Rule 11. However, we are defense attorneys. That is Rule 101. Your client shouldn't talk. And in this particular circumstance, we are saying we don't think she needs to be in Rule 11. So
Oh my
I don't
God.
think waiting around for Dr. Hernandez is going to get us anywhere. We certainly don't need it to meet all of the evidence that is required in the count. And I think one other, the last thing is, we don't see this with the state. How often do we?
Yo, that's what I'm saying. Like, what is she talking about? I mean, like, I don't understand any of it. I didn't even know the first 2 minutes of her talking. I didn't even know they were in Arizona.
You what?
Holy hell, let's keep
See
going.
the state trying to keep a client into Rule 11 proceedings. So we now have Your Honor, who was concerned about the Rule 11 and didn't necessarily think it was appropriate, we have said that. Dr. McGady has now said that. Commissioner Motorosian, who was willing to stipulate to her competency. All of these people who are saying we believe she's competent, you should withdraw Rule 11, withdraw previous counsel's Rule 11, allow Ms. Vallow to be pro per. If at some point you or the state see something.
How many public defenders has she had in Arizona?
That is concerning, we can certainly put her in Rule 11 again. Competency is fluid. Again, we've never seen the state fight to keep
Competency is fluid?
You what?
What?
someone in competency proceedings. It's usually the complete opposite. That's all.
By the way, TikTok, hit the follow button if you're new here. We're listening to Lori Vallow's not trial, what's it called? Hearing about her mental health evaluation. And this is from her down in Arizona, where she's facing what happened with Charles Vallow, the third husband, right? No, the fourth husband. The fourth husband. Because Chad Daybell was the fifth husband. So y'all hit that follow button. And if you want to see this video, you can actually watch the videos with us. We're live on YouTube as well. So it's the Mystery Project over there, y'all. So come on over and say hi. The Mystery Project. Come subscribe. And check out the new layout, y'all. You like it? Hit the thumbs up button. YouTube. You like it?
I have.
Okay. Well, there's a big distinction from the LeCount case in this defendant's case, because according to prior counsel's motion for Rule 11, she was previously found incompetent in another jurisdiction and put into some sort of restoration process.
And then found competent and tried.
Correct.
All we're saying is that where we're at right now, you asked us to come back and give you some evidence of competency. I think we have more than provided that at this point. And at this point, we're just delaying any speedy trial rights, any fundamental right to represent herself.
She's going to try to represent herself?
It's your turn.
If she were allowed to represent herself, prior to that, I'd have to go through a colloquy with her and get some information, and based on that information, could still refer her for a Rule 11, depending on her answers to those questions.
Sure, and that was supposed to be my last point, was we haven't even done that colloquy with her. So let's do that and see where we end up.
All right. Well, ma'am, I am going to ask you a series of questions, and that could inform what happens next. Have you previously, in any other criminal proceeding,
Oh, this is her, y'all. This is going to be Lori talking.
been referred for a competency determination?
Yes, previously.
All right. And will you ever
Damn, why does she still sound like she's 16?
previously determined to be incompetent at any point?
Not to my understanding. So my understanding was that the judge did the same thing that you did, in abundance of caution. Let's go ahead and put her in and see. And I came out competent.
Well, when you say you came out competent, was there a period of time where you were ruled as incompetent?
I would say technically they did do that. That's how they put you into the program in that state. Correct.
How long were you in that program?
I was in that program for about 10 months.
Okay. And what types of things did they give you classes? What types of things did they speak to you about where you went through some process where you were later deemed competent?
I did go through a process of several things, several classes, competency class, and meeting with doctors and evaluators, many evaluators.
Are you aware of any diagnosis that you were given?
Yes.
And what is that?
We're going to object to that, especially with this being public and not sealed.
It's not relevant to this determination.
Okay, well then.
This was almost 2 years
okay.
ago.
Then I'm going to keep her in the Rule 11 process to determine that. And,
Approach and discuss with you without it being on the without public, on the record, but not public?
you mean as far as the diagnosis?
Yes.
Sure.
Or, I don't know how.
See, don't worry, y'all. I got you back. I cut out all the silence because it was like a few minutes of just like, you know, you can't hear anything. I got you. Yeah, we want to know what that was, huh?
All right. All that was on the record. The court reporter took it down despite the white noise.
But it was sealed for the public.
What was that?
That part was sealed.
I haven't sealed anything yet, but I can.
Ooh, what you whispering? She said, "What's that the way you said it?" That judge is not having any of it. Look how mad he looks. He's like, "You want to come tell the whole class? You want to come tell the whole class?"
All right. I'm inclined to keep Ms. Vallow in the Rule 11 process based on the prior attorneys. I understand these attorneys today disagree with the prior attorney's assessment. But because of that conflicting viewpoint, I think I need to let the Rule 11 process play out. So do you want anything additional you want to put on the record regarding that?
There's a couple of, can I just have a moment to?
Sure.
Oh, what she said later about the judge? Oh, snap. What did I say? Ashley, Jennifer, thank you. Y'all hit me with those. Let's get it. Cheryl, the YouTube is The Mystery Project. TikTok, hit that follow button too, by the way. Tap the screen like crazy, hit that follow button. YouTube, hit the thumbs up button. Let's get 100 likes. We have like 20 likes, y'all. What? Come on, you guys. Come on. Ooh, while they're whispering. Jennifer, thank you. Susie, thank you.
I think last part is we haven't finished the colloquy, so we can just finish that, just so that's on the record, and then we don't have anything to add after that.
Okay. I don't see why this would produce a significant delay. If your client comes back competent, I want to, last time you were here, you mentioned needing a lot of time to be ready. But I just want you to think about this, and maybe you want to brief it, is if she represents herself, I don't think she should be forced to waive time in order for advisory council to be ready. I think she can go to trial as soon as she's ready if she's representing herself. And I don't know if you disagree with that, and you don't have to address it today.
We don't have to brief her at all. We agree with the court's
Okay.
conclusion that's if she were going to proceed to trial. under
Jennifer,
speedy
thank you
trial
so
rights,
much.
That's the chance she takes going forward. We would always prepare ourselves as the best as possible under the circumstances, but that shouldn't factor into the decision as to whether someone represents themselves.
I agree.
Put those sentence bounds on that, if that's what the court's thinking. I'm not saying it isn't.
No, you had thrown it out last time that you would need a significant amount of time to be ready, even if she represented herself. And when I was reflecting on that, I was thinking that I didn't know the case. So I'm glad that we're on the same page on that.
before the court goes forward with what I believe it's going to do, I would like the court to make a factual finding and a legal conclusion as to why the court feels it has the authority to do what's doing and the facts that support that.
All right, I think I already have repeatedly.
I would ask the court to do that again, so we make this perfectly clear for the record.
All right. Her prior attorneys requested a Rule 11 based on their observations. In their motion, they cite that she's, in their opinion, suffering from some form of delusions. Next, she's been previously
Jennifer, thank you.
in their motion found incompetent in another jurisdiction and went through a restoration process. By her own account here today, she was in that for approximately 10 months, which seems, I know it's a different jurisdiction and it's a different standard, and but it seems that anyone that's in that process for 10 months is a significant period of time before they're determined to be competent to stand trial. So based on those factors, I think there's definitely enough to continue with the Rule 11 process. All right.
I have one concern.
Go ahead.
Defense counsel has pointed out that they are not happy with the appointment of Dr. Hernandez. Dr. Hernandez did not go outside of the record to review anything. She indicated she had seen something on TV regarding the defendant, and it did not affect anything she was going to do in this case. However, if defense counsel is not comfortable with Dr. Hernandez being appointed, perhaps the court could appoint a different doctor. Most importantly, Judge, specifically due to the basis of the finding of incompetency in Idaho that we just found out today, I think it's incredibly important that the doctors actually speak to the defendant, because the records from the jail may not bring up the issues unless they're specifically discussed. So the doctors would, of course, inquire into those areas knowing that that is of possible concern. So it is incredibly important that the defendant cooperate and speak to the doctors. Defense counsel did indicate that it's
Y'all, basically Rule 11 means that she's going to enter a plea of guilty, or did enter a plea of guilty, but the defense is trying to say that her competency, they're trying, because the previous defense team was saying that she wasn't competent when she said that. If you're not competent when you say that, then you can be like, oh no, never mind, I didn't do this, is basically what they're saying. And now she's trying to say she doesn't want to talk to that doctor to be able to rule that her competency is there and that she isn't, she yeah, it's crazy as hell. But she's already going to spend her life in prison for what happened in Idaho. So, yeah, no, it's just craziness. Let's keep going. This is almost over, and then we got a crazy one to talk about after this, too.
To stipulate to one doctor. That is not the case. I have been doing this for 20 years. It's not what we do. We are protecting the record, Judge, so that we don't come back on appeal for ineffective assistance of counsel when they say it should have been evaluated and it wasn't.
Can I add one last point? And again, this is going to go on for a little bit longer. Even if she does go to trial in February, this case is going to go on for some time. Everybody in this courtroom is going to have an opportunity to see Ms. Vallow, to talk with her. And if there are any issues about protecting the record, it can also be done then. I understand this might be a little bit more convenient, but what we are saying is at this point, it's not necessary.
Okay. Are you requesting a different evaluator?
Yeah, we were going to, yes.
All right.
We're going to do the Rule 11.
We thought the Rule 11 doctor had to do it, so we weren't going to bring it up.
I think I can do it. What was the name of the one?
Dr. Camille Hernandez is the doctor, and we would request that Dr. McGady be ordered to visit the defendant again because of this unique circumstances. He did indicate in his report that his opinion was not as sure as it could be had he been able to interview the defendant. So the state would request that Dr. McGady reevaluate the defendant with an interview, and that this court order the defendant to cooperate to the best of her ability.
Do you want?
Yeah, she laughed at that. Did y'all see that?
We're clearly going down the rabbit hole at this point. We're getting far afield from what the court's concerns are, that she's able to represent herself. Now we're discussing all of the things that are relevant to Rule 11, which I'm indicating to the court aren't necessarily probative of what you need to understand in order to make a determination whether she can represent herself. If she doesn't want to talk to the doctor, she doesn't have to talk to the doctors. That's pretty straightforward and clear.
Did Linda
You're
have
not
a man?
requesting a specific doctor be appointed in place of Hernandez. You're talking about McGady. McGady was the one that found her competent.
Correct, but was not secure in his findings. So we would just request that, and then
Go, the judge got real close to the mic
if you
right there.
just notified the Forensic Services Unit, they will appoint another doctor that does in-custody evaluations, and she can be evaluated pretty quickly.
This is crazy as hell.
One last thing, Judge, we never asked, did the court read the, basically, file a motion to reconsider, including the both reports? Or read those?
Read what?
The reports.
I haven't seen any reports. No.
File a motion to reconsider with the reports attached. I think the court probably should have reviewed those before we had.
You filed a motion to reconsider what?
You filed it under seal.
When was it filed? Are you talking about the motion to reconsider your motion to withdraw Rule 11?
Yes, that we hand delivered last week, I guess it was.
Okay, I issued a ruling that said there was nothing to reconsider because I had neither granted nor
We weren't sure what
denied the motion to reconsider, or the motion to withdraw.
When we left court last time, the court indicated that it would like additional information to make a determination. That's what we provided to the court via those reports that the court asked for. You asked for those reports. We objected to going back to Rule 11, but it was.
I don't know. To me, this seems like a gigantic waste of time. This seems like some kind of crazy red tape, just nonsense. The lady was found guilty of taking the lives of 2 kids. Okay? She's competent. All right? She's crazy as hell, but competent. She knew what she was doing. She did it. She knew what she was doing to Charles, and she did it. This is ridiculous. This is ridiculous. And the fact that she doesn't just come out and say it, yep. I'm going to spend my life in prison anyways. And I did it. And I did this too. Like, at this point, like, what are you doing? Nobody, Lori Vallow, nobody cares about you. Your entire family has, Spiritual Diamond, thank you for that. Your entire family has basically disowned you. You are going to spend the rest of your life in prison. Like, you're just a number now. You're just something that our tax dollars have to keep alive until you take your last breath. That's all you are. So why go through all this craziness? Like, what do you think? You gonna get the Los Angeles Innocence Project to come check you out next?
What?
I highly doubt it. It's crazy. Ruck, thank you for gifting a membership. Thank you. YouTube, hit that thumbs up button. We're about to be on the second one. And TikTok, hit the follow button if you're new here. And do me a favor and do something cool. I forgot what I was going to say. Oh yeah, we hit the puppy dog things. I'll switch it. Thank you. You guys are awesome. All right, let's keep it going. This one's almost over too, y'all. Don't worry.
Determined at some point that there may be some outstanding reports. That's why we set this hearing. That's why we sent you the reports so you could review them before this hearing.
Okay, I've reviewed both reports.
See, I saved you some time there. I cut off the time where he was reviewing stuff. Yeah. Just Kimber, thank you.
All right, the court will appoint a new evaluator through Forensic Services Unit and replace or withdraw Camille Hernandez. I'm not going to order McGrady to go re-interview her. He gave his opinion. If he didn't feel like he had enough to make his opinion, he shouldn't have made his opinion. The state often relies on these opinions as is, so I don't see why this case should be treated differently than is normally treated. So he made his opinion based on the records review and his brief interaction with Ms.
Yeah, dude said, hey, he came in and said he did it, so he did it. Delinda, thank you. Bailey, thank you. Spiritual Diamond, thank you. You guys are the best.
Vallow or Daybell. So I don't know how, once I make that appointment, how quickly they schedule those.
Within a few days, I believe.
Okay. So if is found competent on the second evaluation or opinion, we should be set back here in short order, and we'll talk about where we're going to go next. Is there anything else?
No, I think we just wanted to make sure on the record, so you're denying our motion to withdraw and then ordering that she complete the Rule 11 process.
Yeah, I think that's the safest course of action for the purpose of appeal issues, and once we started it, I think we just need to finish it.
Oh, yeah. Say what?
Anything else from the defense?
That's what because we have a court
She is with the say what.
date with Rule 11, December, I think, December 5th.
Oh, hell. Oh, hell. Stacy, new stuff. Yeah, so this is her in Arizona facing charges for what happened to Charles.
So I think that would be enough time for this.
Well, next week, is it next week that's a short
Yeah,
week?
it's a short week.
I agree with you.
And y'all know why it's a short week next week?
You what?
It's Thanksgiving already. Isn't that crazy?
I think that date should
Bailey, thank you. Spiritual Diamond, thank you.
still work, and if she is deemed competent and the parties stipulate to
Gee, I wonder, is she going to be deemed competent? Oh my God.
competency, you can contact my judicial assistant and we can set it in short order on this calendar.
And just, is the state, just so we're clear, is the state going to be willing at that point then to agree
Bailey,
to-
thank you.
she's
Spiritual
competent?
Diamond, thank you.
Because assuming that the state will stipulate to that,
I don't know. I guess it depends on what the report says. I mean, I agree with you that sometimes the state does stipulate on one report, but there's not a requirement that they have to, so I can't force that stipulation. But I guess we'll see what happens on the
And
next
I mean, so I think the absurd end result here is if the state doesn't want to stipulate, then we're going to have a hearing where the defense is basically saying she's competent, and then the state's insisting that she's not competent?
I don't know. I guess you're going to have to wait to see what the next report says. All right. Anything from the state?
No, good.
All right. We'll be recessed on this matter. Oh, wait.
Joyce, thank you.
Prior counsel, since we're here, prior counsel filed a motion to compel.
yeah.
The state just filed a response.
Well, since we're in Rule 11, isn't everything suspended?
Well, were you going to file, were you urging that motion that prior defense counsel filed, and are you going to file a reply? That's all I really want to know.
We're still reviewing that, Judge. Obviously, we still have to catch up on all the stuff.
Okay.
And
Bailey,
also in
thank you,
terms of
Delinda, thank you.
if Daybell's going to represent herself, that would be something she might want to respond to instead of us. All the deadlines should be stayed because of Rule 11. I realize the state had a deadline that they'd asked for an extension, and that's why they filed it. But the reply obviously will come after the Rule 11 process.
All right, that's fair.
Yes, I think maybe if we could ask for the 3-day reply deadline to start when we figure out where we're at in this process.
That's fair. That's fine. Okay, we'll be recessed.